Hi everyone, welcome back to my channel and welcome to FAQ week, where I answer the top 3 most frequently asked questions about Johnny's defamation case against both The Sun in the UK and Amber in the US. A friendly reminder that just because the trial is over and the media circus is over, that doesn't mean that the case is over, because we do not have a judgment yet, and after all, that is the most important part of a case. So each question will have a dedicated video, so that's 3 videos per week, which is my usual upload schedule, which is why I've decided to call this week FAQ week. Kicking off this week with the most frequently asked question: can Amber and the other witnesses get done for perjury and or falsifying or fabricating evidence? In theory, yes, they can. In practice, it's a little bit of a different story. So the main laws that we'll be looking at in this video will be applicable to the UK, but as much as possible, I will display the equivalent Virginia law for you on the screen. So whatever I say in this video can, for the most part, be applied to the US defamation case as well. All right, so perjury is codified in the Perjury Act 1911 in the UK. Section 1 of the Act defines perjury, but in layman's terms, a person can be charged with perjury if they are lawfully sworn in as a witness in a judicial proceeding and they knowingly lie when under oath with regards to evidence that is material to a case. That final element basically means that if they lie about something that is not an essential matter to the case, for example, they lie about their age, let's say, that has nothing to do with the proceedings, then they have not committed perjury according to this definition. The penalty for perjury is a maximum 7-year imprisonment term and or the payment of a fine. It is an indictable offense, which means it is a serious offense as opposed to a summary offense. And by virtue of that, it doesn't have a limitation period. So theoretically, a charge can be brought against someone years down the line if there is a cogent or compelling reason to do so. It's also worth noting that aiding or abetting perjury, so encouraging others or helping them to commit perjury, is also an indictable offense that has the same penalties that committing perjury does. Now, in the UK, an offense of perjury can also amount to the crime of perverting the course of justice, and we will be looking at this crime right after we discuss perjury. However, if lying under oath is the only crime that that person has committed, then perjury is usually the go-to charge. If the perjury was just one of many acts that were aimed at perverting the course of justice, then in that case, perjury wouldn't necessarily be sufficient, and perverting the course of justice would probably be the more appropriate charge, depending on how serious the offenses are. But again, we're going to talk about this in more detail later in the video. So perjury can be proven by witnesses that are present in court at the time the perjury is being committed, or it can also be proven by using transcripts at a later time. However, it is really important to note that perjury cannot be proven simply by the evidence of a single witness. So if there's just one witness against the word of the person alleged to have committed perjury, then there must be some other form of independent or objective evidence. Of course, if the person admits to committing perjury, then this doesn't apply and we have an admission. A lot of people have asked me whether a judge can actually charge someone with perjury then and there on the spot, and the answer is no, they can't. Judges have the power to charge people with contempt of court on the spot, but with regards to perjury being an indictable offense, it is a crime that must have its own proceedings initiated for it. So usually it's the police that kickstart the investigation, and then it goes up to the prosecution or even the attorney general to decide whether they are going to initiate proceedings against the person for the crime. However, a judge can make a referral to either the prosecution or the attorney general if they personally believe that perjury has been committed. So before we get into whether Amber and her clan can be charged with perjury, let's have a quick look at the available defenses. Firstly, that their false statement was not made under oath or affirmation. That is the key element to a charge of perjury. Secondly, that they believed at the time that the statement was true. Thirdly, that it was an honest or a reasonable mistake. So for example, you mistakenly thought that your driver's license was valid, but turns out it was expired. It's an honest mistake that a lot of us can make. Fourthly, there was no intention to mislead. An example of that is when a witness says something that is maybe a little bit ambiguous or vague, and then it was misinterpreted in a way by the court or by a lawyer that the witness didn't really intend for it to be interpreted, which made out the witness to be a liar. And finally, that the statement was not material to the proceedings. Again, like I said, someone lies about their age, someone lies about their job when it has nothing to do with the proceedings at hand. All right, now for the meat, for the main answer that you're all looking for. Can Amber and the other witnesses who may have lied be charged with this crime? The thing about perjury is it's one of the most underutilized crimes in the book, worldwide. It's essentially a crime that exists on paper that is almost never prosecuted. There are a few reasons why. First and foremost, perjury is a criminal act, which means that the standard of proof applicable to it is beyond a reasonable doubt. If you've watched my previous videos, you would know by now that beyond a reasonable doubt is an exceptionally high standard to meet. It basically means that the trier of fact, so the jury or the judge, must be certain that the crime was committed. There should be no doubt in their mind. So if the prosecution is not convinced that they have enough evidence to meet that standard, they will not charge the person. So cases that would be easy to prove are, let's say you lied about being in a certain country or a certain state or city, but then there was CCTV footage putting you in that location and it was date and time stamped. That is incredibly easy to prove. In Amber's situation itself, I personally believe that there is enough evidence from other witnesses to prove that she was lying in certain situations. For example, in Australia, where there was more than one witness that can testify that she was not injured. So using that scenario as an example, I personally believe that a case of perjury can be made against her. Because if you'll remember, as per section 13 of the act, more than one person is needed to prove that perjury has been committed. So if Johnny's testimony and Ben King's testimony and whoever else was present, Jerry Judge is dead unfortunately, Dr. Kipper's testimony, Nurse Debbie Lloyd, if they all said she was not injured, then it becomes a lot more easy to prove that she was lying. In other scenarios, for example, where she insists that she wasn't wearing any makeup and that everyone else was either lying or mistaken, that's more difficult to prove, because how can we prove beyond a reasonable doubt that she wasn't wearing makeup? All we have is some relatively old and grainy CCTV footage. Yes, we have the testimony of multiple people, but in the eyes of a jury, there will most likely always be that doubt that she did have some concealer at the least, you know? So maybe the rest of her face was makeup free, but the areas in which she was bruised may have been covered by concealer that perfectly matched her skin tone, or any other viable explanation. The main point here is there will be that doubt, and the prosecution will not take that risk because it costs a lot of time and money to initiate proceedings against someone. So if they don't think they have a really good chance of winning, then they're not going to charge the offender. There's also the problem of the jury themselves. Now, because it's a criminal case, there will be a jury. And based on past cases, the jury seem to believe that perjury is not a serious offense. For some reason, whatever it is, most people seem to think that lying under oath is not that serious and doesn't warrant a term of imprisonment or a fine. I personally think it's just a lack of education on the part of the jury, because obviously the entire justice system and court proceedings are really centered around finding the truth, right? Getting the truth out to arrive at a fair decision. So if someone lies, then they are hindering that very crucial core process. The thing about people is, if it doesn't affect them directly, then they just don't care. And the jury, by their very definition, are independent members of the public that have no affiliation or connection to the case whatsoever. The jury are usually very reluctant to convict people because they feel that this person's life is in their hands. So just to avoid that guilt, I suppose, they just decide to take the safe way and acquit the person just in case they're not guilty. So unfortunately, it is one of those crimes that is severely under prosecuted, because when you really think about it, If everyone who lied under oath was charged with perjury, then the cases would just be never ending. And they would clog up the justice system because everyone lies. And yes, including under oath. So as it stands, I personally believe that there is enough corroborative evidence to prove that Amber and or the other witnesses, not all of them, some of them, namely her best friends, lied in certain situations, but whether that charge will ever be pursued seems quite unlikely. And this is really unfortunate because the lies here are actually quite material to the case. The entire case centers on whether Johnny physically abused Amber, and all the lies center around that issue. Now, that's not to say they could never be charged with perjury. Like I said, there's no limitation period, but realistically, they're probably going to get away with it because everyone else does. It's not special treatment, it's just the way this law is. It's truly the poster child for a law that exists in theory, but is rarely enforced in practice. All right, very quickly, let's have a look at the crime of perverting the course of justice. So this crime takes place when a person engages in conduct that has the tendency to, or does in fact, pervert the course of justice. And yes, this includes lying, because you remember I just said, arriving at the truth is a core function of the justice system. And here's the closest thing that I could find in the Virginia Code. This crime actually carries a maximum life sentence and or a fine. A very important element of this crime is in the course of justice. So basically the conduct that they engage in must have been done when proceedings or an investigation are either likely to begin or have already begun. So let's say in this situation, Amber became aware that the libel claim was about to begin, and so she went around telling her best friends and her witnesses to either lie or to fabricate or tamper with evidence. If there is any other alternative crime that a person can be charged with, then that should be pursued, such as perjury or contempt of court. This charge is usually more appropriate where the act of a person can expose someone else to a risk of arrest or prosecution. For example, making false claims against someone when you know that they didn't do it, or the act strikes at the evidence of the case, which includes falsifying or tampering with evidence. When you look at these two factors, they are, in my opinion, again, applicable to Amber because she actually accused Johnny of a crime that could have potentially led to his prosecution or his arrest. And furthermore, her acts strike at the evidence of the case. Fabricating evidence, influencing other people to lie for you or to alter their evidence to match yours. It seems unlikely that this will be the crime that will be pursued as opposed to perjury or contempt of court. Finally, we have contempt of court, which I will look at very quickly. Essentially, contempt of court is when a person interferes with the administration of justice. It could be either civil or criminal contempt, and here's a really handy trick to differentiate between the two. Civil contempt takes place usually when a person doesn't do something that they were ordered to do, and so it is in their power to remedy that contempt. So for example, they didn't show up, they can remedy that by showing up, or they didn't comply with a subpoena. You get the gist. Criminal contempt is obviously a step up from that. So it could be yelling at or disrespecting or hurling insults at the judge or the jury or any person in court, being loud and disruptive in general, influencing members of the jury outside of the court, so trying to get in their good graces or lying to them, or basically even just contacting them at all, because that is completely against the law, by the way. The jury is always sequestered for a reason. That is also contempt of court, even though it didn't happen in the courtroom, and that's indirect contempt of court. Direct contempt of court, as you can guess, are actions that take place in the courtroom itself. This is the Virginia equivalent, and it lists the conduct that is considered to be contempt of court. You can pause the video if you want to have a read of this. Now, you might be confused as to why we're even talking about contempt, because where does lying fall when it comes to contempt of court? Isn't it always perjury? The answer is yes, but then there are cases, specifically in family law matters for some reason, where judges decide to charge a lying witness with contempt of court. Because when you think about it, lying is interfering with the course of justice, because you are basically giving false testimony that could impede arriving at a fair decision. So it definitely falls within the definition of contempt of court. And my personal theory is that some judges utilize contempt of court to reprimand or punish a lying witness because they know that perjury is very rarely successfully prosecuted. If you ask me, this is a great way of dealing with things, and I wish they would be more inclined to use this course of action available to them outside of the realm of family law. I suppose there is a very good reason as to why it's not utilized more by judges, and it's because a judge must be aware that the witness is lying. And a lot of the time, these things are proven after the fact. And it is worth mentioning that contempt of court has a criminal standard of proof. So it too must be proven beyond a reasonable doubt as opposed to on the balance of probabilities. In a lot of situations, this is incredibly straightforward. For example, when a witness is screaming or yelling or hurling insults in court, there is no doubt that they are guilty of contempt of court. But when it comes to lying, you can see how that can be a little bit less straightforward because you need to be aware that they're lying, and you need to be able to prove that they're lying by referring to available evidence that clearly contradicts what the witness is saying. Now, obviously, the trial is over, so any chances of direct contempt of court charges being brought are completely out the window. That's not going to happen. And usually when lies are discovered after the fact, that tends to be more of a perjury charge rather than a contempt of court charge. So again, it's highly unlikely that this charge will be brought against Amber or any of the other witnesses testifying for her or for NGN. So to wrap it all up, is it possible to charge Amber with one of these 3 crimes? Yes. Is it likely to happen? No. So it's a matter of in theory versus in practice. That's it for this video. I know it's a bit of a downer because a lot of you are really keen for her to get charged with perjury. It's an unfortunate gap or a loophole in the system, much like other areas of the law that I've discussed on my channel regarding Davi vanity. So I definitely think that it's an issue that needs to be addressed, but that is so much easier said than done, simply because of the standard of proof that is required to be met. And if you've watched my video on Davi vanity, then you'll understand why there is such a high standard of proof. It's to make sure that innocent people are not wrongfully convicted. I just want to remind everyone that the law is a man-made construct, and man is heavily flawed. Therefore, the law is heavily flawed. Hopefully these things will be addressed at some point in the future to improve the integrity of the justice system, because it is definitely not there yet. And this case, and of course many other cases, are an example of that. Let me know what you guys think in the comments below. I'd assume a lot of you will be unhappy with this knowledge, but nothing's stopping the prosecution from charging her with perjury if they have enough evidence. So you never know. Thank you so much for watching. Stay safe, and I will catch you in a future video.